This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we speak about why it is unwise to be a chameleonic litigant and why it is inappropriate to argue a win was wrong and a new result is required. So don't be a chameleon in court. After winning an argument, it is self-defeating to take a different position. Defendant Bankers Insurance Company moved to vacate a panel appraisal award amendment and clarification based on 3 alleged significant errors or clear mistakes of fact, only to see an unfavorable response in St. Joseph Medical Clinic AMC versus Bankers, a decision of the United States District Court for the Eastern District of Louisiana, dated June 17, 2024. This case concerns an insurance coverage dispute arising from damages sustained during Hurricane Ida. At the parties' request, an appraisal panel provided an award in September of 2022. This initial award provided for $1,066,798.39 replacement cost value under the policy's building coverage and $12,729.86 under the policy's business property coverage. Bankers Insurance disagreed with the initial award's inclusion of $61,485 expense for something called the Rose Office Systems, Inc. within the building coverage. Bankers Insurance took the position in its correspondence that the Rose Systems expense should be categorized within the extra expense coverage, yet Bankers Insurance chose not to pursue the objection and filed an unconditional motion to confirm in May of 2023. The Honorable Donna Corralt, presiding, denied the motion. The court identified the possibility of double counting as a potential significant error that required clarification by the panel. The matter was remanded for that clarification, and the court identified no other errors in an award. The panel issued an amended award in January of 2024, and the amended award explained that the panel had included the Rose Systems expense within the building coverage and provided its reasoning for doing so. The amended award further provided a complete calculation of damages for all the other coverages, including extra expense coverage at 0 and business income loss at $270,409.96. The amended award confirms there was no double counting. Bankers Insurance waited until May of 2024 to move to vacate based on the same alleged Rose Systems error of which it was aware when it filed its prior motion to confirm in October of 2022. Appraisal clauses are enforceable under Louisiana law, and the burden of demonstrating the award should not be confirmed must fall upon the party challenging it. Contractually specified appraisal awards are presumed accurate. Although appraisal awards are presumed correct, the court is not bound to confirm an award that contains clear mistakes of fact. When an award reflects accidental double counting that duplicates certain items and categories, that it is the type of clear error that cannot stand. But the court noted that Bankers Insurance belated objection to the panel's treatment of the Rose System expense is subject to judicial estoppel, and also found that it lacked merit. If Bankers Insurance were to prevail on its first argument and its second argument, the Rose Systems expense would be subject to a lower policy limit. Bankers Insurance first 2 arguments collapse under the weight of its prior litigation strategy. Bankers Insurance moved to confirm the initial award, which concluded that the Rose Office Systems expense fell within the building coverage, and Bankers Insurance made a strategy decision to abandon this objection when moving to confirm the initial award. The United States District Court concluded that Bankers Insurance's prior litigation conduct subjected it to judicial estoppel. Courts can invoke judicial estoppel to prevent a party from asserting a position in a legal proceeding that is inconsistent with a position taken in a previous proceeding. Bankers Insurance asked the court to rule that the initial award set the total amount of damages in this matter, including relative to an award of $1,046,255 under building coverage. In this motion, Bankers Insurance asked the court to vacate the initial award because it contends the initial award's building coverage determination was error. The two positions were simply irreconcilable, and Bankers Insurance Company's argument relative to lost business income misstated the panel's position and also lacked merit, so the court concluded that Bankers, seeking to prevail by arguing that the initial appraisal award suffered from a separate significant error which has carried over into the amended appraisal and requires its vacatur, this attempt to prevail twice on opposite theories renders Bankers Insurance the quintessential chameleonic litigant against whom judicial estoppel is usually appropriate. That is, it made two separate arguments totally distinct from each other. In my opinion, appraisals often raise disputes over the finding of the appraisers. Bankers, although it disagreed with some findings of the appraisers, it moved the court to affirm the award in full. The court sent the dispute back to the appraisers, who submitted an amended award, only for Bankers to try to have the court apply the argument it originally abandoned. Judicial estoppel disposed of Bankers' argument, and the amended award was affirmed. Parties to the appraisal awards should stick to their position and never change their position first accepted by the court, only to ask it to do something different. Insurance companies should never, like a chameleon, change their colors. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. And if you do, you'll be given notice of all blog postings, usually 5, sometimes 6 a week. And you'll also have access to the more than 4,800 blog postings. You can also subscribe to these videos on rumble.com or youtube.com, and if you do, I'd appreciate it if you click on the thumbs up button on Rumble or the like button on YouTube. And if you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider, for a very small fee, subscribing to my Substack publication. Thank you for your attention.